Hello, I'm Dr. Chris Rapoff of QME Continuing Education, and welcome to this week's Case Law Update. This week we're going to be looking into the Bacchus versus Kaiser Foundation Hospital case, where the applicant sought reconsideration of the workers' compensation judge's conclusion that the applicant did, number one, not suffer an industrial injury while employed by Kaiser, and also, there could be a question of the employee's credibility come into play here. So, could the judgment have been in error? Let's take a look and see what the Workers' Compensation Appeal Board's ruling was. Here we have Mr. Bacchus, who's a represented employee. He filed a petition for reconsideration from the findings of the fact and order issued in November of 2022. So they found the applicant in this case that they said did not sustain an injury to his right leg or right foot as part of a CT injury claim through his last date of employment of 2017. So we have 5 years between this ruling and his last date of last employment. And they further issued an order dismissing the case with prejudice. Now, the applicant alleges that the work comp judge erred in finding that the non-industrial injury because they acted with bias and or prejudice toward the applicant when they found his testimony not to be credible. So therefore, he filed and also alleges that the reporting of the QME supported a finding of industrial injury. So here's where the rub comes. Let's get into some background now. So as you remember, Mr. Bacchus alleged that he injured his right leg and right foot by way of a CT injury through his last date of employment in November of 2017. Mr. Bacchus also worked as a patient transport aide for Kaiser Permanente beginning in 2002. So he was working there for 15 years prior to the injury. And the sole issue for this trial became, was it an AOE-COE situation or a Labor Code 4060? There was a question of causation. So in November of 2017, Mr. Bacchus was evaluated by a QME, and the QME noted the following history. He said that while at work in November of 17, Mr. Bacchus began experiencing significant pain in his right foot and also noticed some discoloration and swelling in his right forefoot. In the first report of the injury, the QME also stated that, quote, per the patient, I was simply going about my job duties and then gradually got worse in my right foot. I then removed my sock and my right foot was swollen and bruised. Mr. Bacchus reported no specific mechanism of the injury to the QME. So the QME opined that the applicant's alleged injury was not caused or exacerbated or aggravated by the employment. Now, Mr. Bacchus' PTP, though, noted the following history of his injury. He said, quote, he worked for several years and then in November of 2017, without incident, he began to have right foot pain. So you see the difference here. On the last day he worked, there was an embankment of about 15 degrees, and he had complained about pushing gurneys up the embankment previously, but he continued to do that as part of his job. So after stepping on the embankment and pushing a gurney, Mr. Bacchus believes that he suffered the trauma to his foot when his foot went straight down onto the pavement, toe down. His toes bent forward, he says, the wrong way. And he thinks that it was too much and caused the black and blue marks in his toe, or in his toes. So the QME issued 8 separate reports in evidence, and he was actually deposed twice as well. They initially opined that the industrial aggravation had occurred, but upon review of the additional records, including the applicant's prior claims of injury to the foot and medical report of the QMEs in those prior claims, this new QME changed his opinion and found that the applicant did not suffer any industrial injury at all. In part, the QME based his opinion on the applicant's credibility as a patient and noted, quote, some degree of non-physiologic and exaggerated responses. A little bit of a review here, but when an applicant claims they have a physical injury from work, it's the burden of proof is on the applicant to prove industrial causation by showing that the employment was a contributing cause. And this was a ruling that was stated in 2015, and you may recall the South Coast Framing versus Work Comp Appeals Board ruling. Also, an applicant must prove by way of preponderance of the evidence that the injury occurred, AOE/COE. So here we are, we have a compensatory examination, and we're looking at the 4060 Labor Code. Now, the requirement of the Labor Code 3600 also involved in this case is twofold. On one hand, the injury must occur in the course of the employment, and on the other hand, the statute requires that an injury arising out of the employment. So it has to occur in the course of employment and rising out of the employment. So in other words, the employment and the injury must be linked in some causal fashion. So in general, for the purposes of the causation requirement in the workers' compensation, it is sufficient if the connection between work and the injury be a contributing cause of the injury and not necessarily the sole cause. Now, the record submitted here, they say, does not support a finding of industrial injury. So the Workers' Compensation Appeals Board concluded that Mr. Bacchus actually may have been mistaken as to the QME's findings. And they reference this as Mr. Bacchus repeatedly during his testimony referred to the QME's opinion that the new injury, was 80% industrial and 20% non-industrial. And the QME's opinion, as stated by the board, states that he was clear and that he believed that the injury was 80% prior industrial and 20% industrial in the apportion argument. So the Workers' Compensation Appeals Board stated that it was perfectly clear that no new injury had occurred. And they even noted that the applicant had an injury in 2010 that was accepted, and actually he had a provision of 19% whole person impairment. He was also involved in a motor vehicle accident and had some ongoing and progressive complaints as described by the QME previously in 2017. So the issue here is twofold: whether or not the applicant, number one, was credible in his testimony, and number two, whether or not his increasing symptoms are the result of an ongoing injurious injury, or the CT injury that he's now claiming. The board also found some degree of objective impairment and clear evidence as noted within the chart, and the chart notes that were provided. But in the QME exam, the applicant, or Mr. Bacchus, did not have any objective evidence of complex regional pain syndrome, and clearly had non-physiologic and neurologic responses. Now, based on the QME's examination of the two separate occasions, the QME's extensive review of medical records, and the QME found no credible evidence that Mr. Bacchus had sustained a CT trauma up through his last date of employment in 2022. Also, the QME acknowledged and did not dispute at all that Mr. Bacchus had some ongoing complaints and some degree of objective findings as he described them, but clearly he, as of this examination, as he states, had no evidence of new or further disability on an industrial basis above that and beyond that was from his settlement in 2010. So he is not finding objective evidence for this. So now the parties are going to address the 80-20 causation opinion, and this was addressed in a deposition. So in one of his voluminous number of reports, the QME stated in November of 22 that, quote, there was no credible evidence that the applicant had sustained a CT injury through his last date of employment. We've said that before. But also in another report in October of 2019, the QME commented confirming that there was no complex regional pain syndrome, or CRPS, but that Mr. Bacchus did have permanent disability, 80% of which was industrial and 20% non-industrial. And the QME went on to say that based on the medical record, that there was no objective findings, no CRPS, and no cumulative trauma through the end of employment. So the Workers' Compensation Appeals Board made some conclusions, and they stated that the medical evidence in the case was clear that there was no CT injury found through his last date of employment with Kaiser. Also, they state that the QME's discussion of causation of permanent disability was referring the reader back to a prior industrial injury of 2010, not the current one of 2017. They also said that Mr. Bacchus's arguments to the contrary may have been and appear to be inadvertent misstatements of the record. Now, Mr. Bacchus then continued and argued that the judge actually exhibited bias in noting that he was nervous. And such a discussion was not biased toward the applicant, as the judge said, but they understand that every person who testifies can get nervous, and they take that into consideration. But when a judge sees that, they actually attempt to assist in alleviating any of the nervousness, which also assists the court reporting and taking down an accurate record. So the board judge actually stated that Mr. Bacchus appeared at the trial to be a perfectly nice and polite person, and the fact that he also appeared nervous did not factor into the judgment of the credibility at all, and the question of his credibility. The primary credibility issue, the judge said, in this case is the substance of the applicant's testimony and the changing story regarding the injury. So Mr. Bacchus's testimony was not corroborated by contemporaneous medical records. And the next issue regarding credibility were the opinions of the QME regarding the non-physiologic and some exaggerated responses during the exam. So the judge concludes that their opinions as to his credibility of the testimony were based off the inconsistencies in the record of the applicant's reported presentation at the examination and not at the trial. And finally, the Workers' Compensation Appeals Board judge said in their reconsideration ruling that they continue to find that Mr. Bacchus did not sustain an industrial injury by way of the cumulative trauma that he was claiming, and they recommend that the petition for the reconsideration be denied. So here we have a situation where there were a couple questions regarding causation that were addressed and the time and dates of prior injuries. So we get into the apportionment argument. Was there a prior industrial injury that needed to be apportioned? And there is Labor Code 4664 that we were discussing. Well, here we have another very interesting case, and in this instance we have the applicant, Mr. Bacchus, actually misunderstood the QME's apportionment ruling and based their claim on that. And there was also a question of the applicant's credibility in the QME examination, so there were two questions here. This also illustrates how important it is for us as QMEs to get the applicant's prior relevant medical history in your interview. Without it, the QME wouldn't have been able to provide an accurate apportion analysis as he did. And also addressing the examinee's credibility, both in their answers to you in their interview, but also by their responses to the non-physiologic maneuvers when we assess for symptom magnification on part of the applicant. Now, once again, doctors, I hope you enjoyed this presentation, and it seems to validate the good work that we as QMEs are doing, and we're also strive to provide the best, most accurate QME reports in the industry. I'm Dr. Chris Rapoff, and I wanted to thank you for taking the time once again to join me in this presentation. I hope you've enjoyed it, and I look forward to sharing some other interesting cases with you again soon. Thank you.